Now, good afternoon. Welcome to this National Security Law series seminar hosted by the Faculty of Law. My name is Hualing, Fu Hualing. I'm the interim dean of the Faculty of Law. So that's the fourth seminar that we have organized on this topic. Previously, we examined the framework and highlighted some of the key issues of concerns. And we will continue to explore different aspects and dimensions of the legislation. Moving forward to August, I hope we will have opportunities for some in-depth discussion on academic freedom, police power, and judicial independence. Today, we examine the national security law from a comparative perspective. And the special reference point is Singapore. A comparison on the security law and the practice between the two Asian cities are particularly meaningful. So please bear with me with a slightly longer than usual introduction. Right? The similarity between Hong Kong and Singapore is very easy to see. Both are very small societies with a common colonial history and the use of English common law and the English language, which is the working language in government in both societies, ties both cities very closely to the international communities.
Right. Okay, without further ado, let me just introduce the two speakers. The first speaker is Dr. Kevin Tan, who is adjunct professor at the National University of Singapore. A graduate with LLB from NUS, the National University of Singapore, and LM, SJD from Yale Law School. He specializes in constitutional and administrative law, law and government, law and society, and international human rights. The second speaker is Professor Michael Hall, who is a professor as my colleague, the Hong Kong University Faculty of Law. He was the former dean, my former boss. He's also educated at NUS. I guess, I think get his LLB 1 year ahead of Calvin. He was also educated at Chicago and Oxford. Michael specializes in matters related to criminal law, criminal justice. He has taught and published widely in area of criminal law, evidence, and criminal procedure. So without further ado, I will give the floor to Kelvin.
Thank you very much, Hualing, for organizing this, and Michael for joining me on this little panel. And of course, thanks to all of you who are joining us today on a Saturday afternoon to listen to, a rather technical subject on the security laws of Singapore and Hong Kong. What we propose to do is that I will try and do a presentation on the laws pertaining to Singapore, and then maybe offer some possible comparative observations towards the end. And then Michael will take us through the new security law for Hong Kong, and again, sort of contrast this with Singapore. And while Hualing is absolutely right in saying that, there are many similarities between Singapore and Hong Kong, very often known as the sort of a tale of two cities, very commercial minded and so on. The one fundamental difference, of course, is that Singapore is a sovereign independent state, has been since 1963 as part of Malaysia, and then after that 1965. And so, quite obviously, we are not really comparing apples with apples, but rather apples with a sort of a makes apple peach or something, because you know, as a sovereign state obviously has constitutional arrangements of its own, quite different from one which is got these special constitutional arrangements relating to the special administrative region. So with that in mind, let me now move to my presentation. I will share a screen and take the presentation from there. Okay, so we're going to start looking at the nature of security laws in Singapore. Before I start, and I want to begin with the constitutional regime that Singapore has, I want to explain that what I'm about to share is really a very truncated and summarized version of all the security laws in Singapore. In fact, I did a rough tally of the number of pages in ordinary sort of statute printing, and I estimated that there'll be over 200 pages of text of law, legal text alone, if one were to look at all laws pertaining to security in Singapore. But first, I begin with that one big difference which I mentioned just now, which is that Singapore is a sovereign state, and therefore we have a constitutional regime. It's not quite the same as the basic law in Hong Kong, right? Because that applies only to the special administrative region, but you still do have sort of PRC constitution sort of lurking in the background, and the power of the NPC in interpreting parts of the basic law. In the case of Singapore, you know, with our own constitution, the laws in the constitution and the constitution itself are interpreted by our courts, which are accorded full judicial powers under the constitution. So let me just highlight a couple of constitutional provisions relating to things that would impact security. All right. So I begin with Article 9 of the Constitution. This is your first of your fundamental liberties provisions, where you talk about life and personal liberty. Right. Article 9(1) here, as you can see, no person may be deprived of life or personal liberty, save in accordance with law. So it is not a non-derogable clause. You can derogate from it, provided you do so in accordance with the law. 9(2) goes on to talk about what happens when a person has been unlawfully detained. This is basically your habeas corpus provisions. 9(3) talks about rights of the arrested person. Where a person is arrested, he shall be informed as soon as may be of the grounds of his arrest, and shall be allowed to consult and be defended by a legal practitioner of his choice. Article 9(4) makes it imperative for any person who has been arrested to be produced before a magistrate within 48 hours. In other words, the police will not be able to hold on or to continue the arrest beyond 48 hours of questioning without producing this person before a magistrate and of course leveling a charge. 9(5) not really relevant for our purposes. 9(6) here, nothing in this article shall invalidate any law that is in force before the commencement of this constitution, which authorizes the arrest, detention of any person, or in the interest of public safety, peace, and good order. And the reason for having Article 9(6) is to validate law that was passed relating to national security, public order, and peace, in particular, the Internal Security Act of 1960. Now, that was originally a Malaysian act, but that act applied to Singapore when Singapore became part of the Federation of Malaysia in 1963. And after we left Malaysia in 1965, has continued to be in operation in Singapore. Okay. Now, the other relevant provision is Article 14 of the Constitution. Article 14 covers what we call the public order rights or the ordre public rights, where you talk about first the right to freedom of speech and expression. That's the 14(1)(a). Rights to assembly, peaceful assembly, 14(1)(b). and finally, the right to form associations 14.1c. Now, again, like Article 9, these are derogable rights. There may be provisions that may move you away from these rights. And the other thing that you should note about Article 14 is that these rights accrue only to citizens of Singapore and do not apply to persons who are not citizens of Singapore. Now, it's not a very well drafted provision, I'm afraid, and so there's been some controversy as to, you know, the way it's drafted, because if you say, well, subject to clauses 2 and 3, then does it mean that 2 and 3 prevail? And therefore you have the residual rights, or should you read it as if you have the rights and then 2 and 3 sort of derogate from it? I prefer the second interpretation, of course, because you know, the entire part 3 of the Constitution is about constitutional rights. So 14.2a talks about the rights to freedom of speech and expression, and here restrictions may be imposed by Parliament. Note that it is Parliament that imposes these restrictions on the law, and not sort of the executive. Now, on the rights that are conferred by Clause 1a, Parliament may impose restrictions it considers, and these are the operative words, necessary or expedient in the interest of the security of Singapore or any part thereof, friendly relations with other countries, public order or morality, and restrictions designed to protect the privileges of Parliament, or to provide against contempt of court, defamation, and incitement to any offense. As you can see, there are about 7 sub-clauses here, or 7 reasons why you may not be able to give a citizen of Singapore full rights to freedom of speech and expression, right? So, in other words, if there is going to be a criminal statute that limits free speech, then it must fall within one of these provisions here, right? And the one that usually applies to us insofar as security laws are concerned is public order, right? Generally speaking. 14.2b talks about restrictions on the rights to freedom of assembly, and here there are less grounds, right? So here restrictions may be on account of what Parliament considers necessary or expedient in the interest of the security of Singapore or any part thereof, or of public order. And of course, I think you can see the correspondence, right? You don't want people to assemble in a way that might be a danger to the public, or somehow a danger to the internal security of the state. Finally, in relation to the right to form associations, you may have restrictions placed on you if Parliament considers it necessary or expedient in the interest, again, security of Singapore, public order, and then one further ground, morality, right? So in other words, you know, you shouldn't be allowed to form associations, presumably with immoral purposes in mind, right? So these are the constitutional provisions that are relevant to us. And the point that I want to make here is that while we have many laws, restrictive laws relating to public security, all of them have to be measured against the constitutional provision. In other words, it's got to satisfy the Constitution and be interpreted by the courts and be judicially reviewed by the courts if they are to be accepted as being legal. So let's now move on and look at sort of the public security laws. The main grounds for security laws are usually public order, safety, and national security, right? And so what I tried to do is to bring into focus different legislation. Now, there is no omnibus act in Singapore. There is no one national security act. We've got the internal security act. You've got the penal code. You've got a number of other statutes, and all of which sort of touch on one of these 3 issues, right? Public order, public safety, national security. And in case you're wondering, this picture here, it is actually in Singapore. This was a riot that took place in an area which we call Little India a couple of years ago. Well, you can see the damage that took place. So this is again one of these things which involve public order and public safety, maybe not national security. So what are the key pieces of legislation that we are looking at, or at least I'm going to sort of talk about very briefly? One is the Public Order Act. The Public Order Act is fairly new, but the provisions are not new in that sense, because what they tried to do is to consolidate in one place the rules relating to the control of public order, particularly meetings, assemblies, protests, even special events, commemorative events, and that sort of thing. And so various provisions from all legislation, right, public entertainments, even the penal code and so on, were brought together and put into this act. So it is not as new as the number suggests. And when you see an A after a number, you kind of think that this was an add-on later on, but it is not that new in terms of its various provisions. What is quite new is the Public Order and Safety Special Powers Act of 2018. This was just passed less than 2 years ago. And this act was meant to give enhanced powers to the police in enforcing the Public Order Act. You've got another old act, the Miscellaneous Offences Act, Public Order and Nuisance Act, and it covers some areas that may deal with sort of public security. The Arms and Explosive Act, the Arms Offences Act, of course, the Penal Code, and the Internal Security Act. Now, most of these acts are not new. The first two are fairly new. The first one, like I said, is more of an agglomeration of all legislation that was been put together and sort of systematized. The second one is quite new in the sense that it gives more power of enforcement rather than create new offenses. It gives more powers of enforcement to the police. The Arms Offences Act and the Arms and Explosives Act has been with us for a long time, maybe not as long as the Penal Code, which has been part of the law of Singapore since the time of the British in 1872. Internal Security Act, I've already mentioned just now, was an act which was passed in Federation of Malaya in 1960 and then applied to Singapore when Singapore was part of the Federation, right? All right, so how do these acts sort of operate in Singapore? I think there are three big themes or three ways in which the Singapore state looks at public security, and the various rules can be classified under one of these headings, right? The first I call police and punish. In other words, existing rules, I set out what an offense is, and if somebody has committed a crime, I arrest you and then I punish you. All right. So this is this kind of strategy refers to sort of all criminal laws, existing criminal laws, things that you would find in the Penal Code of Singapore, the Hong Kong Criminal Law Ordinance, for example, is that kind of legislation. All laws setting out, traditional crimes, murder, causing grievous hurt, theft, that sort of thing. So you police and you punish them. That's one strategy under which a number of rules could be classified. The second strategy which the state adopts is by having prior restraint. In other words, before you can do something, you need a license, right? In other words, if you want to have a protest, you have to apply for a police license. If you want to have, you want to stage a show in the open, on open grounds, open to the public, and so on, again, you must get a license. So there are these licensing provisions, right? Which, of course, if you don't get a license and then you go ahead and run your show or your protest, then you are liable to be punished for the failure to get a license rather than anything else, right? Now, assuming that all was well and good, there were no crimes committed along the way, then your main crime would have been in failing to get that license. The last one, which is much more contentious and rather controversial, is the strategy of prevention. In other words, a preemptive strike. Before things happen, before you even get to the point where I need to bring the troops in, I stop you there, right? And here, this strategy applies mainly to national security issues, right? Especially where you think that your national security might in some way be jeopardized, then the executive has power to act in a preemptive way. And this is the most controversial one, where you have preventive detention. This is not an arrest. This is not a police arrest where you are charged with a crime, but with preventive detention, it is an executive order ordering somebody to be detained for up to 2 years, right? I will say a little bit more about that as we go along. But here we have sort of 3 big categories or strategies in dealing with public security, and you can sort of classify the various rules under them. So let's look at the sort of police and punish. The penal code, I don't want to go into these in great details because it's extremely detailed and complex, but broadly, the things that involve public security would be offenses against the state, most serious ones, what you might call, treasonous acts, right? Those are offenses against the state under Chapter 6. You've got offenses relating to unlawful assembly. Again, this fear of large crowds that may get unruly, that may become a mob and so on, riots. So that is also found in the penal code. The offense of rioting is under that chapter, Chapter 8. Offenses relating to public tranquility. This is a little bit different from unlawful assembly. This is where you create a disturbance and so on. Offenses affecting the human body. This, I think, you will find in most criminal laws around the world, involve things like murder, culpable homicide, causing hurt, causing grievous hurt, and so on. Offenses against property. Well, in addition to theft and so on, destruction of property, right? Conversion, that sort of thing under Chapter 17. And finally, criminal intimidation, insults, annoyance, creating a nuisance of yourself, right? That might also be an area where you could say, well, this also touches on public security. So in the penal code, you already have all of this, right? Almost all of this has been with us since 1872. So there's nothing new here. Now, of course, if one wants to take a sort of critical historical look at it, then you say, well, these were obviously put in place by a colonial power, intent on keeping people subjugated, right? Because you don't want them to be able to assemble, as and how they like, because they threaten the colonial state. Well, that may well have been the case, but in the case of Singapore, even after we became independent, we did not actually dilute these laws. We kept them, right? The government decided to keep them, and in some cases even tightened these legislation and made them even more serious in terms of enhanced punishments and so on, right? Okay, so that's the police and punish under the penal code. You've got the Internal Security Act. I know everybody talks about the Internal Security Act in the sense of it having preventive detention powers and so on. But in this particular instance, there are some provisions in the Internal Security Act that also create offenses. So subversive publications, right? These are found in the Internal Security Act. Entertainments and exhibitions where there's a danger that you create, again, these gatherings, these exhibitions that may somehow undermine internal security. And finally, in times of emergency and so on, a proclamation and regulation of what they call security areas, where you actually confine people to a particular space, and there are these rules about moving in and out of these spaces and so on and so forth. So that's again police and punish. Again, it's been around since 1960. No amendments in relation to this, right? Nothing new at all. Then, of course, there are arms offenses, right? Illegal possession of firearms under the Firearms Act, use and trafficking in firearms. That's another provision that's been with us for a long time. These were actually enhanced. They were in the statute books from the 1960s, but in 1970s, because of a spate of armed robberies and kidnapping and so on with arms, these various provisions relating to arms offences were in fact tightened, and the punishments were actually enhanced, such that if you were using, now possession is one thing, possession carries a lower penalty, but if you were actually using illegal firearms and discharging them or attempting to discharge them, the penalty is death, actually, right? Now, what else? You've got the Miscellaneous Offences, Public Order and Nuisance Acts. These are really minor offences, but, still sort of public security, offences against public order and nuisance, making a nuisance of yourself and so on. Soliciting, loitering, unruly behavior, offences affecting public tranquility, touting, okay, minor offences that have some impact on public security. Now, the reason I bring these up, even though they are quite minor, is simply this: the police have an option to charge you under any number of these various acts, right? So you could, depending on how serious the offence appears to be, and you could be charged under one of these lesser offences, which obviously carries a much lighter sentence than those that are much more serious, right? Okay, so let's move on to the second strategy, which is regulation and licensing, right? And here, the Public Order Act is important, right? If you want to have any assemblies of any sort, organized processions, protest marches, or even celebratory marches, right? That sort of thing. We just recently had a general election. Of course, because of COVID-19, all sort of processions have been banned. But if you wanted to have a sort of a victory parade and so on, you would still need to get a police license for that, right? So licensing as a preemptive measure to ensure that you do not encounter public order problems as you move along. Same thing with special events. Special events are a little bit different from assemblies and processions in the sense that assembly events, special events may be commemorative, right? They may be commemorative type of events, or memorial events, and so on. And then finally, of course, there are some offences that are created here affecting public tranquility, right? Okay, sorry, this touting thing was supposed to have been removed. Beg your pardon there. All right, what else? Arms and Offences and Explosives Act also relies on licensing. And here, there are provisions for the licensing for people who manufacture explosive materials and explosives and bullets and grenades and that sort of thing. Singapore actually does have a fairly thriving arms industry. We apparently make some of the best small arms and assault rifles in the world, from what we are told. Licensing of guns, arms, and explosives. And this is where if you have a reason to own guns and explosives, if you were running a security agency and that sort of thing, well, again, it's about licensing. So the offenses would be failing to get a license. And if you fail to get a license and yet still, carry on these operations, then you would be punished for the failure to get these licenses. And of course, within this act, again, a bit of a preemptive thing, there are very vast powers of search and seizure given to the police if they suspect, right, that you may be manufacturing weapons and explosives without a license. The final strategy, of course, as I mentioned earlier, is a sort of a preemptive action through the Internal Security Act. The Internal Security Act, many people don't know this, actually prohibits the establishment of quasi-military organizations in Singapore. It even regulates the use of emblems and uniforms, right? So you don't want an alternative sort of paramilitary organization in your state. Only the state will have that monopoly on sort of police powers, right? Then finally, the power to order executive detention. This has been controversial because in the past, it has been used and actually all that it needs to be shown is that the minister in charge, who will be the Minister for Home Affairs, is of the view that a particular person is a danger to national security, right? Right up to 1989, the Singapore courts adopted what we call a subjective test in determining the minister's exercise of discretion. So when the minister says, well, I think A is a danger to public security or national security in Singapore, the courts have been, were always quite prepared to say, well, if it's the minister's subjective discretion, the minister would know better, the courts don't intervene. But in 1989, in a landmark case, the Court of Appeal actually held that the review of the minister's discretion should be objective rather than subjective. So the minister has to show upon a challenge that the matter does in fact relate to national security. And of course, today the Internal Security Act is mainly used for suspected terrorists and drug dealers. Remains controversial because a person can be detained for up to 2 years at one time, and it can be renewed at the end of those 2 years for a further 2 years. The longest prisoner or the longest detainee anyone has been held in detention actually was Chia Tai Po, who was held in detention for something like 22 years, right? But that's a record. There hasn't been that kind of lengthy detention anymore. Yeah, so this one remains controversial because, this is not something that's subject to proof. You don't go to court and prove a case. There is no need for a special charge. All that is required is the minister's exercise of the discretion, right? So that's the Internal Security Act. So what about the penalties for these various offences? I don't pretend to cover every single offence. That would be impossible. But these are sort of the highlights that give you some idea of what would happen to you if you violated one of these laws. The most serious ones, if you look in the column on your left, the most important ones would be use of firearms. I've discussed right at the bottom. That's death penalty, right? And waging war against the state, right, which is treason. In other words, if you started assembling an army, try and overthrow the government, that sort of thing, that would be life imprisonment. Those are the most serious ones. Then you've got, other offenses like rioting, 7 years, unlawful assembly with a deadly weapon, that's 5 years, unlawful assembly 2 years, unlawful possession of firearms 5 to 10 years plus caning. We still have corporal punishment in Singapore. Threat to national security, this is a bit of an odd one, which is, as I mentioned to you, under the Internal Security Act, up to 2 years and renewable. If you look on the right column, these are offenses, and by the way, many of these offenses are in, sort of existing in the penal code already. Some of them are enhanced under the Internal Security Act or the Arms Offences Act. Causing death not amounting to murder, in other words, culpable homicide, life imprisonment, or the 20 years plus caning. It all depends on the severity of the case. Death in furtherance of a group object. So if you went out on a protest and you were determined, to hurt somebody and somebody dies as a result of it, again, life imprisonment or 20 years plus caning. Grievous hurt, 5 years or $10,000 or both. Causing hurt, 3 years or $5,000 fine or both. Criminal trespass, going onto property that's not yours, for example, 3 months or $1,500 or both. And finally, the licensing ones, right? Organizing assemblies, processions, and so on. Without a license, no jail term, but up to $5,000 in terms of a fine. By the way, these are in Singapore dollars. So for our friends in Hong Kong, I think you just sort of multiply that by 5 to get a sort of approximate conversion on what the fines are like. So let me just sort of end off here by offering some comparative observations. I must confess that I only went through the Hong Kong security laws more thoroughly sometime during this week, and I don't pretend to be an expert on any one of them, but quite clearly in Hong Kong you also have sort of existing criminal law that sort of are very similar. You didn't have the penal code. Hong Kong was unusual among the various British territories in Asia and Africa that did not in fact adopt the penal code of India, right? So what are the various comparisons? As I started off, I said Singapore is a sovereign state. We've got constitutional protections, and that protection is guaranteed by the Constitution and reviewable by the courts. Right? This is quite serious. Whereas in Hong Kong, obviously, you've got the basic law, and even in your Security Act, it speaks of an adherence to the rule of law, international human rights conventions, in particular the ICCPR and ICSCR. But I think the way in which they operate will be a little bit different, simply because you're not a sovereign state, right? There is a more sovereign state than the SAR. A unique feature of the Hong Kong legislation has to do with secession. Of course, Singapore doesn't worry about secession. First of all, it makes no sense. I mean, what are you going to secede? It's Singapore is really, really small. I mean, you don't secede, and there are no provisions actually in the Constitution allowing any portion of Singapore to secede, right? But if the government of Singapore wishes to surrender its sovereignty, in other words, if you want to become part of a bigger country, rejoin Malaysia, for example, or become part of Indonesia or whatever, then you would require 2/3 majority at a national referendum. That has, of course, never happened, but these provisions are in Part 3 of the Constitution. In the case of Hong Kong, one of the outstanding parts of the legislation, the new legislation, is that it is an offense to advocate and promote secession of the Hong Kong SAR, very draconian in terms of punishment, right? Every time, if you were the person organizing these things or the leader and so on, you could face up to life imprisonment. Both countries have the power to make their own laws, but in Singapore, once Parliament makes its law, that is final, subject, of course, to the constitutionality of that law, which will be determined by the courts. In the case of Hong Kong, legislation, sort of conditional. We have no special omnibus security law. Like I said, most rules are predicated on ordinary criminal law. But in Hong Kong now, you've got, sort of this very large, looming new security law. In terms of strategy in ensuring that you do not end up with a public security problem, I think the focus on the Singapore government has always been on prevention and regulation rather than on punishment and deterrence. Sure, you've got all these laws, criminal laws that exist, and that has to exist, right? But in terms of the other things like, public gatherings and so on, the preference is prior restraint. Preference is you get a license. If you don't have a license, you can't do something. And of course, if the government has intelligence that you are about to, I don't know, embark on some really major national security activity, right? Such as organizing, an attack on, I don't know, government house or something, then they could use, again, a preventive law like the Internal Security Act to arrest you. Doesn't seem to be the case in the Hong Kong instance, where the heavy punishments that are cast in the new legislation seems to favor deterrence rather than prevention. I may be wrong, and here I'd really love to hear what Michael has to say about this. Finally, insofar as public security matters are concerned, they are adjudicated as like in any other case, through normal court procedures. There are no special courts. Nobody gets to pick the judges. No judges are selected because of their views about, secession or anything of that sort, which seems to be the Hong Kong case, right? You just go through the normal court processes and you assume that the court, in the exercise of its independent judicial power, will be able to give you, what hopefully is a fair and just trial and a result. What struck me as rather unusual was the provision in the Hong Kong legislation allowing the CE to pick judges and even disqualifying judges who may hold a view that maybe Hong Kong can be more autonomous than it currently is. So let me pause there and return the screen back to Hualing and to Michael. Thank you very much.
So as I said, there are two sets of relations which are fascinating for our understanding of the Hong Kong national security law. One is the relations between constitutional rights and the national security, whether they exist in entirely separate universe. I guess my more pointed question is to what degree and how the constitutional rights can really bite, right? To have a certain controlling function when it comes to national security. And the second relations which is fascinating is to look at the criminal law regime, which is a normal system controlled by the normal criminal procedure with judges at the controlling point. And then, of course, there is the internal security regime, which by and large exists outside of the normal criminal justice system, and how a decision is made between the two separate systems, and what are the standard. That will be a fascinating question for us in Hong Kong to know for a better understanding the future operation of the national security law of Hong Kong. So let me invite our second speaker, Michael, to continue the conversation. Michael has been writing on the matters extensively, in particular the relationship between the Singaporean criminal law and the Internal Security Act. So the floor is yours.
I want to thank Kevin for the very comprehensive survey of laws in Singapore relating to national security. I'm going to do something opposite, which is I'm going to focus here. So I think it will take us the whole day to compare law for law. So what I'm going to do is I'm going to, let me see, share this screen. Right. That is, okay, I'm sharing the screen, just a minute. Okay, okay, just a moment. Right, yeah, there we have it. Yeah, what I'm going to do is I'm going to first look at the broad principles on which human rights are thought to be protected or not protected under the Hong Kong legislation and the Singapore. What I think is the centerpiece of the Singapore legislation. So for Hong Kong, I'm going to focus on the recent security law that has been passed, and for Singapore, I'm going to focus on the Internal Security Act, and in particular, preventive detention, as Kevin has described. When we first look at the Hong Kong legislation, and we see in Article 4 something which I, in fact, was quite surprised to see. It says, human rights shall be respected, the rights and freedoms enjoyed under the basic law and the provisions of the ICCPR, the International Covenant of Civil and Political Rights, shall be protected. And this, on the face of it anyway, seems to be quite an important concession to human rights. As we shall see later on in Singapore's position, we will see how striking this Article 4 is. Some questions, of course, remain, and this will determine the extent to which Article 4 will truly protect human rights enjoyed under the ICCPR. Just three small points here. The first one is that is whether or not the rights reasoning here shall be used to inform the court's interpretation of the criminal law definitions here. We shall see in the next slide what these crimes are. But I think you probably know from the press that that many of these crimes are drafted in a very broad fashion. So the question is whether the courts which will apply these laws will use human rights reasoning to narrow down the definition of the crime so that it becomes consistent with a robust rights protection. So that is a question mark that we will have to watch out for. The second point is similar in the sense that what if there is a provision in the basic law or the ICC, if there's a provision in the security legislation which is on its face contrary to an ICCPR protected right. Right, and I'm thinking, for example, of something in Article 44, which I think Kevin has already mentioned here, which is the executive nomination of specific judges to hear prosecutions under this act. The executive nomination of specific judges to hear cases. I think this is the one feature of the Hong Kong security law which troubled even someone as unflappable as retired Chief Justice Andrew Lee. That he actually went public saying that he has serious reservations about this law. Now, so you have this situation where Article 4 says these rights are to be protected, and you have Article 44, which appears to contradict the rights. So what is the court going to do in such a situation? And of course, the third point about respecting human rights is that under Article 55, and this is something which has alarmed a number of people. The mainland criminal justice system, as it were, has the power. Well, has the power to take over certain prosecutions, convictions, and trials under Article 55. And once that happens, Article 57 says that the law of the mainland applies. Okay, so I am definitely not anywhere near knowledgeable enough about the criminal processes of the mainland to make an assessment of whether the ICCPR rights will or will not be protected. But certainly, if there is a difference, if there's a difference between the mainland processes, whether in theory or in practice, and Hong Kong's theory and practice, then it becomes a serious question whether Article 4, once Article 55 is invoked, will be of any meaning. Okay? So that is Hong Kong, right? So at least we have a sort of a baseline statement that the usual rights, the regular rights and freedoms will be enjoyed. In Singapore, we need to look at Article 149. And Article 149 is in fact the provision which enables the Internal Security Act to be enacted. Okay, so Article 149 is supposed to be subversion legislation combating subversion. And the effect of Article 149 is that once a law is enacted under 149, it is exempt from several major rights here. And this is mentioned in Article 149. For example, the due process clause it does not apply to such a law. And quite surprisingly, even the Article 11, which is retrospectivity and double jeopardy. So technically, under Article 149, the Singapore Parliament can pass a law here, which would create retrospective crimes here. Of course, it has not done so, but it certainly has the power to do so under 149. It overrides the right to equality, Article 12, and it overrides the freedom of movement, Article 13, and definitely Article 14. Yeah. Kevin has shown us the text of Article 14, yeah, and even if Article 14 applies, yeah, there is some debate, yeah, about how strong a protection it is on the freedom of speech, assembly, and association. But even if whatever rights you have under Article 14 can be overruled, yeah, in a sense by legislation under Article 149, and so this is the sort of framework, yeah, that we are working on. Yeah. The Hong Kong security law is, on its face at least, presumptively respectful of human rights. Article 149 in Singapore, when it concerns legislation combating subversion, is exempt. Yeah. It doesn't have to follow any of these rights that are listed there. Okay. Right. I'm now going to sort of run through, yeah, the primary strategy of Hong Kong's legislation. Hong Kong has this legislation, yeah, has created what I call the gang of four crimes, yeah. And they are the crimes of secession, subversion, terrorism, collusion. Yeah, I'm just putting it here because I think that there probably are webinars which will go into these things in great detail. Yeah. So I'm just going to sort of skip, just to walk you through a few things, just to have a flavor of these four crimes that have been enacted under the security legislation of Hong Kong. The first one is secession, and this essentially is participating in separating Hong Kong or any other part of China from the PRC with a view to committing secession or undermining national unification. If I'm not mistaken, this was not a crime before, and it has now become a crime. So in fact, the legislation makes this a crime for the first time. Okay. Subversion, however, is different. Yeah. If you look at subversion, there are no less than 4 different ways of being guilty of the crime of subversion. I won't go through them here. For example, overthrowing or undermining the basic constitutional system, or the interfering with performance of duties, and so on. But for any of these limbs here, A to D, it must be by force or other unlawful means here. Right. So, in a sense, the crime of subversion does not create a different offense here, because it must be unlawful or by force. Yeah. By force, I would assume to be unlawful force here. In fact, what this provision does is to create a more serious offense here, where there was one before here. So there was, for example, damaging premises and facilities was an offense before. But if you damage premises and facilities of the government, right, with a view to subverting state power, then you are guilty of this enhanced offense called subversion and held liable to its punishment regime, yeah, which I think compared to damaging premises per se is quite high. If you look at the below, yeah, the punishment principal offender 10 years to life, active participant 3 to 10 years, others up to 3 years. Yeah. I found that the way that the punishment provision is drafted to be quite interesting, because common lawyers don't do such things. But it is interesting here that the legislation actually splits up the classes of offenders, yeah, to principal, active, and others. Yeah. And for each of them, they have a different sentencing range. Yeah. Well, in practice, even in common law jurisdictions, yeah, there is normally some some internal unpublished kind of tariff, which is something like this. Yeah, but it's interesting to see a law which actually expressly mentions it. Terrorism. Yeah. Again, terrorism is something like subversion in the sense that these things are already crimes. Right? But if you commit, for example, serious violence with a view to intimidating, coercing the government or intimidating the public, then it becomes a more serious crime of terrorism. Yeah. It was a crime before, but it becomes a more serious crime now. Yeah. Collusion, yeah, the fourth one, is one of those crimes which have rung alarm bells again. And you'll see an interesting picture. Yeah. So there's different kinds of collusion. If you look, there's 1, 2, 3, where is 3? 3, 4, and 5. 1 to 4 appears to create, to make collusion an offense where there was no offense before. Yeah. So, for example, the most famous example of this is our activists who go to the US, go to Europe to request a foreign institution or organization to impose sanctions, yeah, on Hong Kong, yeah, or hostile activities. Yeah, I think that has been. It looks like hostile activities would be interpreted to include things like perhaps offering a pathway to citizenship for British or overseas national passport holders. But 5 is more like subversion and terrorism in the sense that it must be predicated by unlawful means. So this provoking hatred amongst residents towards the central or Hong Kong or the HKSAR government. Yeah. Now this one has worried a lot of people. Yeah. Because if you just look at provoke hatred amongst Hong Kong residents towards the government, yeah, it isn't in a sense what oppositions are supposed to do, right? Hatred might be a very strong word for that, but it certainly provokes disaffection. Yeah. There's a similar word in the Singapore legislation, and they use the word disaffection. I suppose they cannot be very different. So 5 is predicated by unlawful means. So if you just provoke hatred amongst Hong Kong residents towards the government, that is not a crime. It must be provoked by unlawful means. Yeah. So this is more like subversion and terrorism, where it is an activity which was a crime before, and then it becomes a more serious crime because of the national security sort of flavor to it. So that is Hong Kong's gang of 4 crimes, I call them. Of course, we do not know how it will be interpreted. Officials have been pronouncing on whether certain things are or are not a crime yet. So I was quite surprised to read, for example, that the recent democratic primaries were thought to be in violation of, I think, one of these things. I can't remember which particular one. Yeah, but it could be it could be interfering with the performance of duties or formulation of state power, one of those things. Yeah. So, but I think the general lesson we can draw is, yes, much of the language is broad, yeah, and perhaps a little bit too broad. But if they're going to be read in the light of the ICCPR protections, as I hope they will be, then that is a possible way of taming these provisions. Yeah. But the point is that this legislation keeps within the criminal law strategy. In other words, it requires the state to go through the criminal process, and a criminal process which is supposed to respect the ICCPR rights. Now, Singapore's primary strategy is in contrast here. As Kevin says, yeah, there are a whole raft of criminal offences here, which has a national security flavour here. But I will just ignore them for the moment, because the centerpiece here, or the crown jewel of Singapore strategy, is in fact what is known as preventive detention or executive detention. Why preventive here? In the sense that, if you look at the way that the power is granted by Section 8 of the Internal Security Act, it is with a view to preventing any person from acting in any manner prejudicial to the security of Singapore. Okay. Now, if we were concerned with the broad language of the Hong Kong legislation, I think you will be terrified by this here, because that's all. There's nothing more. Yeah, it just says security of Singapore, prejudicial to the security of Singapore, maintenance of public order, or essential services. That's it, right? You can see by the brevity of expression that it is even potentially broader than anything you see in the Hong Kong legislation. And of course, the other point to make is that it is preventative here, as Kevin has said. For crimes, you have to do something first, and then you are charged for doing something. But here, the government can act against you even before you do anything, if it thinks it necessary to prevent you from doing something. Right, and this goes beyond merely. I mean, criminal lawyers will know about the law of attempt and so on, where the law can get at you even though you haven't quite done what you haven't quite done any damage yet. But this goes beyond that. It goes even beyond the law of attempted criminal law. So that is that's why it has sometimes been called preventive detention, and it is sometimes called executive detention, because it is the executive government which gives the order to detain you. For a criminal charge, we all know that it has to go to the courts, and the courts must sentence you after a due process. But in the case of this kind of detention under the Singapore law, it is literally on the say-so of the executive government, meaning the minister, the prime minister, the cabinet, or in some cases, the president of Singapore. Okay. So, and the order can be to detain you, in other words, just take you and lock you up, or it can be a restriction order. In other words, you can't go out after 8, something like the COVID restrictions, which you're also familiar with now. It could be to wear an electronic tag. It could be to report to a police station every 6 hours, whatever. Okay. So it has full power to impose any of these restrictions on your liberty. And a detention order is not to exceed 2 years at a time, but it is renewable indefinitely. And again, as Kevin mentioned, we've had someone who was detained for 24 years, and even after that was subject to another few years of restrictions. He was, I think, put on an island where a small little island that he could not leave. So I'm not sure whether you consider that to be a real release here. But anyway, the point is there is no limit here. This is something akin to, in the criminal law, it would be life imprisonment. It has that kind of a flavor. Now, as we know, this process does not go through the court. Right? There is no charge, there is no trial, there is no sentencing, there is just an order from the minister. But there is something called an advisory board, right? And the advisory board, as the name suggests, advises the government on whether the detentions or restrictions were justified or not, right? So there is a right for the detainee or the person who is subject to the restriction order to make representations to an advisory board when he or she is first detained, and once a year after that. That's provided for in Article 151 of the Constitution. Okay. Now, how useful, how good, how effective is the advisory board to prevent wrongful detentions? Right? The answer must be not. It's not very promising, because, for one thing, the advice is not binding. Well, That's why it is an advice. But there is one wrinkle to this. If the advice of the advisory board is to release the detainee, and if the government disagrees with that advice and wants the person to be continued, then if the president concurs with the advisory board to release the detainee, then the government must do so, right? And this is a new provision, Section 13A. So, in other words, the advisory board plus the president can override the wishes of the government. That has never happened, and it doesn't mean it will not happen. Just a brief footnote about the president and the government. Singapore used to follow the common law, Commonwealth tradition of the president being a figurehead and the president acting only on advice of the government. But a few years ago, that changed, and now the president is directly elected and has a legitimacy or base of his or her own. And so the president of the country does now exercise certain real executive powers here. And this is one of them. So it all depends on who the president is. If the president is very closely allied to the government, then of course this protection is not so strong. Now, who sits on the advisory board? They are to be appointed by the president, but this time on advice. In other words, he has to follow the government's advice. So notice that we were talking about earlier on in the Hong Kong legislation that the chief executive can nominate certain judges. Well, we have it here in full force because the president on advice means the government. So the government is the one who appoints the members of the advisory board. Okay, so it appoints the chair, who is either a sitting retired judge or someone qualified to be a judge, and two other people. Right, the two other people in consultation with the Chief Justice, which is a good thing, but notice consultation. So the advice of the Chief Justice need not be followed. So, in other words, this is very similar to the executive government putting in judges here to hear the cases here, except that this one looks even more clear. Proceedings are to be in camera. There's no exception. The advisory board's rules say that it must be in camera. In other words, none of the proceedings can be talked about, can be examined, can be scrutinized in public. And in fact, there is a provision that the government is not obliged to disclose anything if it thinks it will not be in the national interest to do so. So this is a completely closed box here. Whatever happens, we don't know and we cannot know. And so you might ask, in this whole system, is there any avenue for judicial review? The answer is longish, but to cut to the chase, there is no judicial review except on procedural grounds. So you can complain if, for example, instead of someone who was supposed to have signed the order turned out to be someone else, or something like that, or if some process or procedure has not been followed. But apparently you cannot judicially review a decision to detain you on any substantive ground. So and that is the result of a provision, Section 8B, which in fact was enacted following the case the landmark case that Kevin mentioned just now. So that door, I think, it looks pretty closed. Right. Yeah. So I'm going to end. This is my last slide. If you look at what I've been talking about here, you should be more scared of the Singapore legislation than the Hong Kong one. But and the perception seems to be, or maybe, I don't know, maybe I'm moving around the wrong circles, but the perception seems to be that that is the other way around here. So why is Hong Kong's law more scary, or maybe I should say, why why does Hong Kong's law appear to be more scary? And here I offer a number of thoughts which are, I admit they might be completely speculative, but it's strange when people talk about how because of this law they're going to move their office or move their operations from Hong Kong to Singapore. What is operating in their minds, right? Because if you look purely at the legal framework, right, honestly, it doesn't look so bad. In fact, Hong Kong has stuck to the principle of due process. Singapore has not. Now, the first point perhaps I'd like to make is that people have become less scared of Singapore. I started researching on preventive detention laws. When we were students, soon after that, young lawyers, and in the 80s, it looked really scary. But I think what we have seen in Singapore in the intervening years is a steady liberalization. Right? It is no gigantic radical steps here, but we can see that the atmosphere has changed. And if you look at the trajectory, right? In Singapore, it's starting from 10, it has come down to 5. Right? Just one example. In the 1980s, in a very famous incident, the Internal Security Act, or Preventive Detention, was used against a group of Catholic social workers, right? And on the argument that they were neo-Marxists and so on, subversion and that sort of thing. No one in Singapore now can countenance the same thing happening today. So, in other words, if these Catholic social workers were operating in Singapore right now, doing exactly the same things as they did in 1988, 87, 88, right? Nobody would think that the government would use would detain them for that purpose. Right? It is still used mainly for religious extremists who are thinking of resorting to violence or great damage to property to further their religious ends, drug trafficking, and in an interesting case a few years ago, even football match fixing. I am not a football fan, so I don't know how serious this is, but obviously this appears to be a very serious thing. Football match fixing. Someone in Singapore seems to have been in the center of this match fixing ring. The match fixing case was not under the Internal Security Act. It was under another act called the Criminal Law Temporary Provisions Act, and which has very similar, gives the government a very similar power to detain someone if they are thought to be connected with criminal activity. Right? There are actually two laws which provide for detention without trial. So, if you like it, in summary, Singapore seems to or appears to be, steadily liberalizing, has improved in terms of human rights, and remains a relatively stable political climate. For those of you who are following the Singapore elections, many people agree with the Deputy Prime Minister, Tharman Shanmugaratnam, who said that, in fact, although the ruling party lost about 9% of its share of votes, right? The result is actually good for Singapore. It's good for the stability of Singapore because the people who are dissatisfied with the government have had a chance to express themselves, kind of the safety valve. Right. Now, when we move to Hong Kong, right, I think the perception anyway is that there has been a trend of deliberalization. So if you like it, Singapore started with 10, now it's 5. Hong Kong started with 1, now it's 5. So although it's maybe the same, the trajectory is what is scaring people. I don't need to say very much about the sort of deliberalization trend in Hong Kong and the reduction of political space. I've just listed a number of incidents which have been used to show how things are tightening. There's not the kind of space there was before, and so on. Right? I won't go into them, but I'll just mention it. So that's the one thing. Yeah, trajectory. Right? It's not so much where it is at, but where it is heading. The next point, autonomy. And I think for Singapore, we are talking about Singapore institutions, Singapore courts, Singapore government, Singapore everything. Right? So it is a known quantity, and like it or not, they do have electoral legitimacy. The people know what they do, and the people vote them in. Hong Kong is different, right? And of course, its constitutional position is very different. It is not a sovereign country, and therefore cannot have the kind of doesn't have the kind of electoral legitimacy that Singapore has here. But quite apart from that, there are aspects of this security legislation or law which seems to consciously bypass the Hong Kong institutions. For example, formulation and drafting entirely outside of Hong Kong in Beijing. I assume it is Beijing. And what was difficult for me to visualize was the chief executive saying on the eve of the promulgation of this law, I haven't seen the law. I mean, this to anyone in any other context of Hong Kong, this would be like I don't know, fantasy. But yes, it happened. The other thing is that the mainland security apparatus has been set up in Hong Kong. In other words, there is this whole institution here set up under the control of the mainland government, which has nothing to do with the Hong Kong government. And even though there is this National Security Committee set up under the Act, which is headed by the chief executive, I think the general thinking is that the de facto leadership of this committee is actually the National Security Advisor, which has been appointed, who is appointed by the central government. So, we see that it isn't really the Hong Kong government legal system that they're dealing with alone. And of course, the law also sets up special courts. We know that the executive appoints particular people to sit on a panel or to be qualified to sit in these special courts to try these crimes. And there's also a provision for special prosecutors here, right? So not any old prosecutor can deal with these cases. So just as there are these special judges who will hear the case, there are these special prosecutors also appointed by the chief executive on approval of the central government of these special prosecutors. And of course, the sort of the centerpiece here of this is the Article 55 power of what I call extraterritorial prosecutions. In other words, at any one time, the central government can say, I'm taking over this prosecution. And from that point on, the whole process moves to the mainland. It is no longer the concern of the Hong Kong court. And so you have to follow whatever procedures, whatever, you'll be subject to whatever protections that the legal system of China affords. So that is all I have to say, and I will ask Hualing to switch back to the other mode. Thank you.
Thank you very much, and thank you for the wonderful presentation. Particularly, I like the idea that Singapore is moving forward. We are falling. So I was looking at the Freedom House ranking on civil political rights. Now Hong Kong is last year 55 out of 100. Singapore is 50. So we're getting very close in terms of the standing on civil and political rights. So I guess there are other questions before I pose questions from the audience. my own question is this, right? The Internal Security Act, I think this year is 55 years anniversary. I think it was passed in 65, something like that.
1960.
1960, right? So it's 60 years.
60 years, yes.
60 years. So looking back, I mean, Michael, you just said, you know, the jurisprudence and some of the takeaway from the history. You also have written quite extensively on the changing, I guess, in a way, psychology in Singapore towards internal security, basically detention without trial. So what's the jurisprudence? What's the takeaway? If you have to tell someone in Hong Kong, of course, after 60 years experiences, what would be the things that you would say, I mean, to ordinary people who have the legitimate concern and the fear? So in a ways, was the fear more prevalent in Singaporean history? And of course, gradual, you mentioned the term of the gradual trend of liberalization in Singapore. And so are you saying that by now it has been accepted as sort of legitimate part of the entire legal system? You may not like it that much, but then nobody would pose a serious challenge to that system. I guess still the question is, are there still pushbacks, and people still say, well, we should, so for example, follow the Malaysian example to simply change it, abolish it, morph it into something else. So is the voice still there, or people say, well, since it is more limited, there is a procedure, right? So it has become acceptable.
Kevin, you
Is Michael? Is this directed at Michael or?
Oh, yeah, to both.
Kevin, please go on.
Yeah.
Okay. Well, let me try and take that question. Well, first of all, Michael, thanks. I wasn't thinking of a football match in the way that you were. That you end up scoring, because it might end up, doing a lot of own goals going down the line. But I think I absolutely agree with Michael in terms of the sort of trajectory that has happened. Now, if you look at the status of the Internal Security Act following the so-called alleged Marxist conspiracy detentions of 1987, it was very much vilified. Many people were very unhappy. Of course, it caused a lot of us to fear that there might be a knock on the door in the middle of the night. Some state agents might come and just whisk you away, and you're going to be detained ad infinitum. You don't know. And I think throughout the 1990s there was always this kind of calls for a pushback. But what had happened after that, and notwithstanding the fact, and here I know Michael mentioned the point that Parliament actually amended the Internal Security Act after the case of Cheng Suanzi, the famous 1989 decision of the Court of Appeal that held in favor of an objective discretion, in other words, objective test in the executive discretion. Now, I would argue, and of course it's never been challenged, that in fact the amendments would be unconstitutional. I think they clearly go against the judicial power of the state. But anyway, that's another matter altogether. What began to happen was there was a pushback. People began to say, well, you shouldn't have this, the law. But at the same time, you saw a number of prominent people sort of hint at their own disagreement with those particular amendment detentions, including later on government ministers who said, well, I really resigned. Dana Balan said, I resigned because I didn't agree with these detentions. So in other words, there was, it wasn't a monolithic decision of the state. There were people who thought that law should not be used. Now, just as the Internal Security Act was beginning to get, extremely unpopular and so on, it kind of, I hate to say this, received a shot in the arm with 911. And suddenly, you know, everyone's talking about the ticking bomb syndrome. What do you do? Do you lock the guy up, right, before this happens? Or do you wait till, you know, something's about to blow up in your face and then you go arrest the guy, or after the fact, right? And so it kind of got a new lease of life. Now, along with sort of a general international concern that, you know, and there was also this other case where some, I think it's called Om Shinrikyo guys in Tokyo that released sarin gas in the subway and killed a lot of people. People were saying, well, if only we could have locked these guys up, but if only we had like Singapore's Internal Security Act. Okay, so you had some things on the international plane happening that kind of roll back on possible reforms, right? But at the same time, you also saw that the local authorities were beginning to be much more careful about how you would use this law. And whereas in the past, I would say right up to the mid-1990s, where there was hardly any information, where they will not tell you who's being detained, you literally have to get somebody to file a parliamentary question, and even then they might not reveal all the details. The Ministry of Home Affairs took a slightly different tack. They actually were coming out and telling you, I've got so many guys who are being detained, and these are the guys that are being detained, and they're detained for, you know, what purposes, right? At one point in time, quite a lot of people who were detained for drug-related matters, drug trafficking, where, you know, somehow it's impossible to get hard evidence to convict them in an open court. And then subsequently, you know, in recent years, and they've been, you know, and this is out in the national newspaper all the time, so-and-so has been detained because, you know, he's supporting ISIS. This guy, you know, wants the president killed because, you know, he's been radicalized and so on and so forth. And they actually tell you who has been released at the same time. So there's been a very serious, you could call it a public relations campaign on the part of the state to tell you, look, we are not abusing this, okay? We're telling you who these guys are. And if you really think that, you know, we shouldn't be detaining these people, well, you know, think again, right? And coupled with the fact that even the law minister, the home affairs minister tends to be the same person, also goes out on kind of a roadshow to various fora explaining some of these decisions. So you've got, you know, sort of two things going on. You've got the courts, on the other hand, being very clear that they will observe the objective test. And this was what happened in the Dan Tan or the Tan Sit Eng case, which involved the match fixing. They ordered a release. And, you know, not only did they say that, you know, it was against, you know, it did not fit into any of the grounds in the Criminal Law Temporary Provisions Act, but suggested that, you know, the power of judicial review over this is something of a basic features of the Singapore Constitution. So you had the courts being more assertive on these points, giving some confidence to people that, hey, you know, I could challenge this. You've got sort of international developments that cause people to think maybe, you know, we shouldn't tamper with it. Everyone was watching Malaysia. I'll let Michael talk about Malaysia since he's actually Malaysian, right? You know, and everyone say, wow, if Malaysia can do this, we can do the same too. But let's see what they did in Malaysia.
Okay. Michael, can you speak to the mic? People cannot hear you clearly. Yes.
Okay, I'm going to come nearer.
Yeah.
Is this better?
Yeah.
Okay, good. I hesitate to say anything on Malaysia because I really don't know what's going on there. I'm not sure whether anybody does. So anyway, just a brief response to Hualing. My own impression is that the debate in Singapore is not about should we have the power of preventive detention or not. I think most people would agree with the government having such a power. I think the debate has gone on to what can be built in, what can we do to prevent abuse. So that's the same with the Internal Security Act or the Criminal Law Temporary Provisions Act. So the answer to your question is, I think there is definitely a general acceptance of the concept of the detention without trial, and the controversy is over what kind of conditions limits judicial review and so on.
Thank you. Let me just go through some of the questions. One that quite a few questions on this. So the question is whether there is an overreaction in Hong Kong, especially from the business, right? There are people are saying to move the arbitration cases to Singapore because they're concerned of national security law. The data companies are sending their the backup servers to Singapore for the concern of the breach of security and some of the requirement. So of course the question is whether the protection of privacy, data, and the fairness in commercial arbitration in Singapore would be better than Hong Kong because of the security law.
Well, I think you can anticipate my answer to that. It's not so much the law as it stands now, yeah, but it's a question of how it is going to be applied and what the trajectory is. Yeah, is it going to get worse? Yeah, are there going to be more and more of such laws? So I think that is it's more the concern rather than just what the law is right now.
Yeah, if I can just chime in. Actually, if you just look at the law itself, if I were a businessman, I wouldn't be too worried because you're not about to foment rebellion or advocate secession or collude. Well, this collusion part is a little tricky, right? Because who are these foreign powers, especially if you are a foreign company invested in Hong Kong. That one may be something that they may be a little bit concerned about. But it's about increasing or diminishing trust. And I think this is where the business, business people are very simple. They want stability, they want certainty, and they want to make money. I think you can make money in Hong Kong. The question of certainty and stability, this is where they are getting a little bit nervous, I think, right? But every move may shake that confidence. I think that is the main concern, not the law in itself. It's the law. It adds up, right? You had the extradition law. You've got the protests. You've got the way in which the protests were handled, and then you've got this law. You see a sequence of events, and then as the businessman, you then make your calculations and you say, okay, where is this going?
A factual question is, since the inception of Internal Security Act, how many cases there have been, and what type of cases, especially in the 60s, 70s, and 80s? Well, now we know lots of them are related to terrorism. But before that, what type of cases are there?
Okay. We don't have actual numbers. I don't think they've ever released. There was a white paper that actually released numbers up to, I forget, 1990s. I think there was a white paper that gave numbers at that time. The Internal Security Act has been used. Well, the biggest exercise, dragnet, was something called Operation Cold Store, right? When in 1963, a large number of political actors, mainly members of the opposition, leaders of trade unions, and sort of various organizations, were locked up under Operation Cold Store, which was a joint operation with the Federation of Malaya and the British government. And this was about 113 of them, mainly for subversion, but with declassified papers, we found that, well, some of them looked like they were locked up simply for their political beliefs, right? So that was the big one in 63. And then subsequently, there were others. And quite honestly, right up to the end of the 1980s, many people perceived the ISA as actually a political tool. Yes, you had a number of drug traffickers, but isn't this just not a tool for you to use to silence your opponents, right? Well, things have shifted. As far as we can tell, there has been no political detainee since 1987, as far as we can tell. All right. Well, of course, we don't have perfect information, but as far as we can tell, that's the case. And from the late 80s onwards, what you see are, and at least this is information that's being released, people connected with the drug trade, and mainly, people involved in sort of supporting extremist religious organizations like ISIS.
Right. Anything to add, Michael?
I'm saying that, well, I just want to say that I think the Singapore government grew smarter and realized the cost of using the Internal Security Act. And so, in fact, what happened subsequent to the Catholic social workers incident is that the government enacted the Religious Harmony Act, which they said was a kind of a soft version of the Internal Security Act. Under that legislation, you don't lock up the person. You issue him an order to ask him to shut up. Yeah. So, so that is a kind of and they thought that was enough. Yeah. So instead of locking them up under the Internal Security Act, all you need to do is to issue an order under the Religious Harmony Act to prevent the priest or whoever it is from saying anything. So there have been a number of such legislative innovations here, which they could use instead of using the Internal Security Act.
Right. I like this question. Right. If someone from Hong Kong went to Singapore, put on masks, and says, "Liberate Singapore, revolution of the times," what would happen in Singapore?
So what would you say after you put on the mask?
Everybody
put on a mask these days, so it makes no difference.
Liberation of Singapore and the revolution of the times.
What would happen?
These are two popular.
I'm gonna have a semi-joke response here.
Yeah.
What's going to happen is that person is going to be detained, not under the Internal Security Act, but under the Mental Health Act.
Okay.
Actually, I think Michael is half right. This is not somebody who's going to be detained under the Internal Security Act. You see, this is something I think many people don't kind of understand about the psyche of many Singaporeans. Singaporeans do protest, but they don't protest in the way that other people protest. So if you ask people, would you go out into the streets and protest and do these big marches and so on? I mean, in a Hong Kong parlance, I mean, are you joking? It's so hot. It's just not practical, right? So in other words, so that's why Michael's response is only half joking, because people will think you're crazy, rather than you are actually fomenting rebellion, right? And if you make too much of a nuisance of yourself, you might get taken away and questioned, and then maybe released just because you're creating a nuisance and disturbing people. No, the intelligence services, I think, are a little bit better than that. If they thought that you were going to really foment rebellion, you wouldn't even be able to start doing it.
Right. Could you just move up a little bit the question? Yeah.
There are quite a number of questions.
Quite a few. I think. I mean, that's a general question, right? So what's your impression? I think for both of you of the Hong Kong national security law. And I think we talked about this already. Is what would be your advice really to the government, the people, I guess that is, I mean, quite a few questions are related to that. So.
I think I am hardly anybody to advise the Hong Kong people. I mean, really, you know, I mean, I think Michael makes a very good point that if you just look at the law itself and you want to compare with some country like Singapore, it really doesn't look too bad. There are problems, just like there are problems in the Singapore law. But I mean, you know, laws, in order for them to be useful and legitimate, must function in an organic way, in the way that responds to public requirements and sentiments. I think that's important, right? And so if the people of Hong Kong don't think that the law addresses a real threat, then I think it's going to be difficult for people to accept it as being, you know, useful.
Yeah, Michael.
I think the most sensible thing about this has already been said by you, Hualing. When you said that, I think you said something like, if I read correctly, that now that the law is there and there's no prospect of removing it, the best thing they can do is to just leave it there and not do anything and not use it at all. Yeah. I mean, that is very wise advice, I think, and perhaps in time people will forget it is even there. Yeah.
Wow.
But if it is used, then you know all the fears start rising again.
Right. I guess that will be a challenging thing to do. I mean, that will be my own best case scenario. But then we don't know. There's a question is not related to the security, but then it's the question about Singapore's protection from online falsehoods and the Manipulation Act. Any comments on that in relation to the security of Singapore? Would that law, you know, either safeguard the security or limits freedom of speech? Any comments on that?
Gavin? Yeah.
Wow. Well, POFMA, the Law of Prevention of Online Falsehood and Manipulation Act, or POFMA we call it, is a fairly controversial act. It's a huge act that actually gives the state ministers tremendous power to actually, in a way, you could say it's almost like legislating the right to right of response to potential online falsehoods. The interesting thing about it is that, as many of us had discussed in the lead up to its passage, was that it actually can be a sword that can cut both ways, because it can actually backfire on you. Because every time somebody tries to say that something is a falsehood, you've got a rollback on the other side. So that actually people are saying, well, let me use it as a device to get real information out of the government. So I don't need to file a parliamentary question. All I need to do is set up a blog and say ridiculous things, right, about something that I don't like in Singapore. And I know it's false. I want them to tell me that it's false. And in order for them to show that it's false, they're going to tell me what the truth is, right? So this is what is really happening with the act. Does it safeguard the security of Singapore? I think I think people are a little bit more intelligent than what POFMA makes us out to be. That we need to be told all the time that this is false, this is not true. Now, Singaporean voters tend to be quite savvy. They will try and ferret out information, and they will not just believe something because it comes from the state, or they will not believe something because it comes from A or B or whatever it is. They will try and ferret out the truth, and this is what has been happening. So one of the reasons why the ISA is not as powerful and as blunt a tool as it used to be is that there are many sources of information today which sort of challenges the state monopoly on power in that sense. So my roundabout answer to you is that POFMA can be used to protect national security, but it's not really the way you want it to be used, because all it can do is to tag your site or tag your post and say, this is false, and tell you, where to refer to what is true. If you ask me, it actually gives the government departments a lot of work to do. The poor civil servants will always be trying to ferret out what are the falsehoods and then provide the actual information so that you can correct these falsehoods. And which is why people are saying, okay, let me put something ridiculous. Let me put out, what I think the Prime Minister's salary is or what his wife's salary is. And I'll put up some ridiculous figures so that, maybe they'll tell me what the real truth is.
Well, my response is that, I mean, my anecdotal opinion is that the people who have problems assessing the veracity of online information are mainly people of our generation. The old people who when we grew up, we didn't have computers yet. We didn't have the internet. So I think that there might be some thing to be said for something like POFMA for that generation. But for the young people who grew up with it, they know. They don't need POFMA they don't need POFMA to tell them that this might well be false, or that there's alternative views and so on. Why? Because they grew up in such a system. We didn't. So we have a problem there. I get increasingly annoyed with some of my contemporaries when they just pull out something from the internet and say, "Wow, true." But that the young people do not do it to me. It's people of my generation. So there might be some, but we'll be concerned enough.
Right. In the past few weeks, foreign responses to Hong Kong's legislation have been particularly harsh and strong, right? Criticizing the legislation, ending treaties, threatening further actions. How about judges, right? We haven't heard much from foreign judges. Hong Kong courts do use a large number of judges among permanent judges. So what were the responses of the foreign judiciary in Singapore in the early days, right? In the 80s, was the internal security a serious concern? Did it matter for foreign judges or foreign responses in general?
I think judges, by and large, generally don't go around commenting on what they think about what happens in other people's jurisdictions. Even in the 1980s and 1990s, the most vehement critics of the Internal Security Act from abroad tended to be legal counsel, English legal counsel, QCs, SILTs, who acted on behalf of detainees, right? And then, of course, the various international organizations like International Commission of Jurists and Human Rights Watch and that sort of grouping rather than judges. Now, if one wants to take issue with this, the decisions of the court are not so out of the ordinary that you could lambast them. Okay, in other words, that in all jurisdictions, there's always sort of the more conservative approach and the more liberal approach to doing anything. And really, the line of precedence that the Singapore courts adopted was actually one which the English courts have adopted before, just that the English courts later moved away from it. So you can't say that, well, it is so extraordinary. It is something that is so unusual, right? That it warrants critique.
Michael, anything to add?
Well, there were appeals to the Privy Council in London up until somewhere in the 80s, I think, and
89, yeah.
89, and certainly the Internal Security Act was used right up to then. I think that well, as it turns out, the appeals to the Privy Council for the Internal Security Act was very hastily stopped. Stopped in I think 89, in order to preempt an appeal. I can't remember the details now. It's something like that. So I think that there's certainly, well, the earlier generation of judges, I think the English judges in the 60s and 70s, seem quite happy to live with that Internal Security Act and all that. But I think as rights consciousness began to grow in Europe, in England, I think by the 80s, I think some of the UK judges were already seeing problems with Singapore's regime. But that was when the Privy Council appeals stopped.
Yeah, but to be fair, I think the decision in Cheng Suan Tzu itself showed that the local judiciary was also conscious of that shift, and they shifted accordingly. In fact, they looked at all the sort of relevant judgments from all over the Commonwealth and said, well, it's high time we abandon the subjective approach. We should opt for the objective approach, right? So it's not just sort of waiting for English judges or foreign judges to tell you. I mean, I think the local bench at that time was already beginning to realize that this was an outmoded a kind of regime, or at least a test, and they wanted to move away from it.
Right. Okay. Let me have this final question, which probably needs some explanation. I think Kelvin said at the very beginning, I think rightly, so that in Hong Kong, so Hong Kong is not sovereignty. There's a big government in Beijing, right? So the central government makes a decision, passes legislation, and now we have this law. The difficulty is there are lots of things that have been happening on the ground. We're not quite sure from which government, right? We know the law is from Beijing, but then some of the concrete actions, say the protocols on campus, there are things that can be said, there are things that cannot be said. There are posters that can be annulled, there are posters that cannot be annulled. So we're sort of second guessing, is that instruction from Beijing or instruction from the Hong Kong government or just instruction from Hong Kong police? We don't know. So the question here is that there are people in Hong Kong now try to push for legislation, creating a new criminal offense that is to insult, the insulting words towards police officers, which of course is vaguely defined. If you insult police, will be criminal offense. The question specifically is whether Singapore has an offense of insulting police officers.
No, of course not. I think there are offenses where you do anything that will prevent a public officer from performing his or her duty, and that clearly applies to police officers. I mean, police officers are treated like anybody else for the purposes of so-called insult, right? I mean, if it borders on the level of a threat, for example, well, that's a threat. And threatening a public office holder is certainly an offense. So no, there isn't a special offense like that.
No, the offense isn't just insulting. I think it's under criminal intimidation. Yeah, criminal intimidation, as Kevin says, requires a threat against some sort of threat, against the public officer or the police officer. And in Singapore, I think it definitely is an offense. And it was
penal code, yes.
A few years ago, I think the maximum penalty was raised, if I'm not mistaken. So in that sense, it is,
Right. Well, thank you very much. As I said, time flies. Now it's the end of the 2 hours, right? So there are lots of things that there are so many questions which we haven't had a chance to answer and to discuss. I think comparative law is important in this matter. Otherwise, people say, well, no, Singapore has this law, we should have it. And nobody would think seriously whether Singapore actually has this law. There are lots of people are saying that the US does that, UK does that, therefore we should do it. Before I end the session, there's just one thing which I meant to say at the opening, but didn't get a chance to say. There are many reasons for business to move to Singapore, but the national security law probably is not one of them. I was looking at some of the rankings, right? Compare Hong Kong with Singapore. I mean, Singapore, in Hong Kong, we think we do pretty well on many things, but it doesn't matter what we do, Singapore does better. In some areas, far better. And let me just give you a few examples, right? World Bank Good Governance ranking, right? We rank 17 among 209 economies. So we think we're pretty good. But look at Singapore. Singapore is the third, right? Far better than us. Rule of Law Index. We think we are pretty good. We are number 16 among 128 jurisdictions. Singapore number 12, right? Hong Kong is 16. Well, there are many other things. I think corruption is the Transparency International's the perception is important for Hong Kong. Hong Kong ranked 19, second, almost I think second best in Asia. Singapore is number 7. Has always outperformed Hong Kong. Of course, look at GDP, which is close to everybody's heart. Of course, both societies are very high. The GDP per capita in Hong Kong is last year is near $50,000 US, extremely high. Singapore is over $65,000 US. So in all the indicators, we may not believe indicators, metrics, but if metrics, all of them point to one direction, we have to take it serious. So I haven't mentioned NUS is a better university by ranking than Hong Kong U. I haven't mentioned the NUS Law School is a better law school than Hong Kong U Law School by ranking. So ladies and gentlemen, there are lots of things to do in Hong Kong. We will continue our seminars, conferences on the national security law in the next few weeks. As I said, we will have a few sessions on academic freedom, judicial independence, and police power. So we would appreciate your participation, and I'm looking forward to meeting you online again. So take this opportunity to thank two old friends, Kelvin and Michael is actually with us. So it's a grateful presentation and interesting discussion. I learned a lot, and thank you. And I hope we could have other opportunities to continue the conversation. So now let me thank the speakers and thank the audience. And enjoy the evening and have a nice weekend. Thank you.
Thank you.